My name is John P.L.C. I'm a probate litigator in Florida with the P.L.C law firm in West Palm Beach, Florida. I'm going to be speaking to you right now about abuse of discretion and probate appeals in Florida based on a recent case. Today is April 21st, 2016, and I'm going to speak to you about probate appeals. If you're involved in a will contest in Florida, or a petition to overturn a will or to revoke probate, or for that matter, if you're involved in Florida trust litigation under Chapter 736, Florida's Trust Code, you should be considering appeals both prior to your trial and also during your trial. Why? Well, if you prevail, the other side may file an appeal, and you want to make sure that you're as much as possible bulletproofed on the appellate issues. No probate litigator or trust lawyer in Florida likes to go through an entire trial, prevail, and then have that matter overturned on appeal. Likewise, if there was an error of law which occurred during the trial, you want to make sure that you preserve that issue for appeal, because if the judgment in your inheritance lawsuit or your trust lawsuit in Florida is not to your client's liking, you may want to seek a district court of appeals review of that particular order of judgment. You may want to appeal that. So let's talk about appeals from a very limited circumstance for the moment. We're going to talk about probate, estate, and trust appeals. Remember now that for the most part, rulings of law, errors of law are appealable. Findings of fact necessarily aren't appealable, right? Now, there may be an abuse of discretion by the court in making findings of fact when they're not supported by substantive evidence. When a probate court makes a finding of fact or a conclusion that is not supported by competent substantial evidence. There also may be an appeal issue when the court abuses its discretion, right? Trial courts have great discretion. They can weigh the credibility of a witness. They can determine whether that witness is truthful and helpful or not credible and not believable. And in estate and inheritance lawsuits in Florida, not only in Palm Beach and Broward County, but throughout Orange County and Tampa and in Naples and in Sarasota, we're calling witnesses every single day, every single trial, to testify about what the decedent believed or the circumstances surrounding how your mom or dad signed a revocable trust or an amendment to a revocable trust, or how their estate plan came about. So witnesses are very, very important. And the inferences that are drawn by a probate court from evidence that is presented need to be reasonable. When those inferences aren't reasonable, when a probate court judge exercises its discretion in an unreasonable manner, or not based on competent substantial evidence, let alone contrary to competent substantial evidence, that may be abuse of discretion. So, if you're involved in probate and estate litigation, what is abuse of discretion by a probate court judge during or prior to your inheritance trial? Discretion is abused when the judicial action is arbitrary, fanciful, or unreasonable. Whether the exercise of discretion by your probate trial judge is unreasonable or arbitrary is best considered by and answered by your probate litigation law firm in Florida, as well as their appellate counsel. If you want to read more about abuse of discretion, you can read the April 20th, 2016 opinion of Thomas Nance v. Marcio Nance. It's a Second District Court of Appeal case from April 20th, 2016, case number 2D, 2nd District 15, a 2015 case, 2320. It discusses very briefly the definition of abuse of discretion by a trial judge in Florida and lists other citations that may be helpful to you. That concludes my remarks about this probate estate appellate appeal in Florida.